Okay, so good afternoon, everybody. It's my great pleasure to introduce Professor Brian Leiter from the University of Chicago Law School. Brian is the Carl Cohen Professor of Jurisprudence and Director of the Center for Law, Philosophy and Human Values at the University of Chicago. Brian, as many of you will know, has written many significant contributions very widely across legal, moral and political philosophy, amongst other areas. So let me now, without further ado, hand over to Brian, who's going to talk today on legal positivism as a realist theory of law. So thanks, Brian.
Thank you, Mark. Everybody can hear me fine without the microphone? Okay, good. What's that?
We checked.
We already checked. The machine can hear me too. Okay, good. I know the paper was pre-circulated. The handout covers a number, but not all of the issues that are taken up in the paper, so I'm not going to talk about everything in the paper in my remarks, but I'm happy to talk about other parts of the paper during the Q&A. So this was a paper that was commissioned for the Cambridge Companion to Legal Positivism. The task was to talk about legal positivism and legal realism. The editors are both Scandinavian legal philosophers, and as many of you will know, there are two official legal realists that are in the canon, or just barely, partly again due to H.L.A. Hart, the Scandinavian legal realist, and the American legal realist. I'm going to talk mainly about the Americans. I will say a little bit, though, about the fact that American and Scandinavian legal realism have essentially nothing in common except the word realism. And I'll explain a little more about that in a bit. But let me start. In prior work I've argued, and I'll explain today why I think this is true, that the American legal realists are tacit legal positivists. They are implicitly committed to a positivist theory about the nature of law. This paper, as it were, takes a reverse course and argues that legal positivism, or more specifically Hart's version of legal positivism, is and ought to be thought of as a kind of realist theory of law. So let me just start by saying what I mean for these purposes by legal positivism and what I mean by realism. So this is 1A on the handout. By legal positivism, I'm going to emphasize two main claims, and we can talk perhaps later about why I don't go in for the, law as a matter of sources rather than merits approach to characterizing it. I think the two crucial claims are, first, that where a legal system exists, there exists a rule of recognition specifying the criteria in virtue of which norms are valid norms of the legal system. And of course, this was a thesis Ronald Dworkin denied. But I take it positivist theories in the Harshian mode are committed to this. And then secondly, and quite crucially, a rule of recognition is simply, as Hart called it, a kind of social rule, right? Which means that a rule of recognition is nothing more than a complicated, complex psychosocial artifact constituted by the practice of officials in the system, right? So if you ask what is the content of the rule of recognition in a legal system, it is whatever criteria of legal validity officials converge upon and which they accept, as Hart puts it, from an internal point of view. That is, they treat as obligatory, right, or obligation imposing. And that means, of course, that laws and legal systems rest at bottom on nothing more than the conventional practice of the officials. The conventional practice changes, the system changes. By realist theories, okay, and now here I'm using realism in the sense that we associate with Thucydides, with Machiavelli, with realism in international relations theory. Realist theories, for my purposes, have three characteristics. First, they aim to describe without sentimental or moralizing allusions what law is and how it actually operates in human societies. So descriptive adequacy is supposed to take priority over moralizing sermons. Second, realist theories recognize that law is never adequate to explain how courts adjudicate all cases that come before them. That is, non-legal considerations play a role in explaining the decisions in at least some range of cases. And third, realist theories account for law and adjudication within the constraints of a naturalistic theory of the world. Right? By a naturalistic theory of the world, I mean one that eschews any appeal to entities or properties that do not find a place in successful empirical scientific accounts of natural and social phenomena. Okay? Now, I want to emphasize this kind of naturalism is what I usually call methodological naturalism rather than substantive naturalism. Substantive naturalist starts with some view about what is the natural stuff that really exists. The methodological approach, as it were, defers questions about what there is and what we know to successful empirical sciences and not just natural sciences. Right? And I'll maybe say a little more about that in a bit. Okay, so that's what I'm going to mean by positivist theories and realist theories about law. Let me just mention, call attention to some ways in which Hart's legal positivism is a realist theory in these senses. Right? So first, right, law for Hart in modern legal systems operates primarily outside of the courts. I think this is one of the crucial points that Hart is making, and quite correctly so. It operates outside the courts as a way of guiding ordinary people, sometimes with the help of lawyers, as to what they can and cannot do, as well as how they can acquire various legally created powers, as well as avoid going to court. Okay? And any general theory of law that focuses primarily on courts, think Ronald Dworkin, is not realistic in this sense. It actually gets the role of law fundamentally wrong. Right? People go to lawyers not to end up in court. Right? They go to lawyers to figure out how they can make a valid contract, right? Establish a corporation, get married, get divorced, and so on. And I think Hart quite rightly puts this front and center. The American legal realists share with Dworkin a focus on courts, but they also don't actually have an explicit theory of law, a point I'm going to come back to. As I say, they have an implicit or tacit commitment to a positivist view. Second realist aspect of Hart's view, he recognizes that adjudication of some legal disputes inevitably involves judgments that are not constrained by law, but instead require the exercise of discretion informed by non-legal considerations. And the contrast, of course, is with a theory that presents adjudication as always a matter of discovering pre-existing answers existing in some legal heaven to all questions. All right. Third, for Hart, law is explicable in wholly naturalistic terms. Right? That is, for Hart, we don't have to assume that there are objective moral truths, nor do we need Kelsenian transcendental conditions on judgment. Law and legal systems exist entirely because of psychological and sociological facts about persons, in particular the facts about what officials treat as criteria of legal validity and the attitude they take towards those criteria. And finally, law is not morally binding. Governance by law, first of all, has costs. I think that's very clear in Hart. There is not the assumption that you find, I think in aspects of the natural law tradition, like Finnis and others, that law is somehow always a moral good, or at least a legal system that is practically reasonable is always a moral good. And indeed, for Hart and the entire positivist tradition, we should never presuppose that law is morally good or obligatory. Right? And any theory, again, Dworkin's is a good example, that builds the justification of coercive power, the moral justification of coercive power, into the nature of law is not going to be a realistic theory. Okay. So those are some respects in which I take it Hart's view deserves to be characterized as a kind of realist view. And now I want to say a bit about some of the ways in which the realist views are positivist views, right? But first a bit about American and Scandinavian realism. And the first point to make, and I think the misunderstanding on this score, at least in the Anglophone world, is due to the fact that Hart treated the Americans and the Scandinavians as a pair, as having the same kinds of views. I think in reality they have nothing in common except that they both were attached to the word realism, right? Now the irony is they were attached to the word realism in two different senses. The American realists were realists roughly in the sense I described at the start, right? That is, they were appealing to the colloquial connotation of realism as looking at how things really are without, moralistic or optimistic illusions about what's actually going on. That's the sense in which they're realists. The Scandinavians, in fact, adopted the label realism initially because they were reacting against idealists in the traditional philosophical sense. That is, they were metaphysical realists. They were committed to the mind-independent reality of the world against idealist philosophers who thought that reality was, in some sense, constituted by the mind. And that is actually how the label arose for the Scandinavians. This shouldn't be entirely surprising. The Scandinavians were all trained philosophers or with serious interests in traditional philosophy. The American realists, by contrast, were pretty much all lawyers, judges, and legal academics. Indeed, one of the most famous of the American realists, Jerome Frank, was never an academic. He was a trial lawyer for 20 years. Then he directed the Securities and Exchange Commission under Franklin Delano Roosevelt, and then was a judge on the U.S. Court of Appeals for the Second Circuit. The one exception was a guy named Felix Cohen, who did have a PhD in philosophy, and I'll come back to him in a minute. But just given those backgrounds, you would expect them to have different kinds of concerns. And I think the right way to think about the Scandinavians is that the Scandinavian realists were primarily concerned with what Frank Jackson has helpfully dubbed the location problem. That is, the problem of how do we locate certain kinds of phenomena in a world that is conceived naturalistically, right? That is conceived to be how the successful empirical sciences describe it to be, right? So versions of the location problem would include questions like, how do we locate the phenomenon of conscious experience in a world naturalistically conceived, right? Or more precisely, what's the relationship between conscious experience and the neurophysiological events that are taking place in our brains? In the metaethical realm, the question is, how do we locate the phenomena of moral rightness and wrongness and goodness and badness in a world naturalistically conceived? And for the Scandinavians, it was generally a question about how do we think of the normative concepts in law, like obligations or duties and rights, from a naturalistic point of view. And I'll come back to that in the case of Alf Ross in a moment. The Americans, totally different focus, right? The American realists thought of themselves as trying to disabuse lawyers of mistakes that they might make in advising clients about what the law is, and in particular advising clients about what courts were likely to do with respect to any particular dispute. And the central arguments of the American realists, and now here I'm going to put Jerome Frank a little bit on the sidelines because he was actually an outlier among the American legal realists. And indeed was always a little sensitive about it because the other American realists would kind of say, well, we don't have Jerome Frank's view. Jerome Frank's view in his theoretical writing, not when he was on the court, interestingly enough, but in his theoretical writing, Frank's view was, how do you explain the decision of a court? The decision of a court is the facts of the case plus the personality of the judge equals the decision. That was one of his formulas, right? Which is to say, there was no room for, right, in that picture, law as a factor in explaining the decision, right? There are facts of a case, and then there is the idiosyncrasies of each judge's individual personality. Frank is writing in the 1920s and 30s. It's the heyday of Freudian psychoanalysis in the United States. Freud himself was psychoanalyzed, and Frank himself was psychoanalyzed. Freud was too. Frank was psychoanalyzed and recommended that all judges should be psychoanalyzed so that they would understand their idiosyncratic reactions to the facts of the case. Okay. Let us forget Frank. If anything, he is responsible for the view that what the judge ate for breakfast is how they decide the case, even though he never said that, but he had this view that it was all idiosyncratic. Most of the American realists, of whom Carl Llewellyn, Herman Oliphant, Walter Wheeler Cook, and many others, had a different view. And they started from a very practical lawyer's observation, which is that it was, if you were a competent lawyer, possible to predict how courts were going to decide cases, which you wouldn't expect to be true, of course, if it was all determined by the idiosyncrasies of personality. Right? And the American realists first, the majority of the American realists, they first point out that legal reasoning is often indeterminate. Something H.L.A. Hart agreed with, though for slightly different reasons that I'll come back to. For the American realists, right, the claim was that even if you agreed on what the authoritative sources of law were, say statutes and precedents, it was still the case that in many cases, and especially they thought in cases that reached the stage of appellate review, which of course is a rather small segment of the universe of legal questions that arise, they argued that in these cases that reached the stage of appellate review, even if the judges agreed on the authoritative sources of law, they had available to them equally legitimate but conflicting ways of interpreting those sources so that they could extract two different rules from the same source. So in one of Llewellyn's famous examples, he said, with respect to any precedent, you can read the precedent very strictly. That is, you can treat the rule of the case as tied very closely to the particular facts of the case. And if you read it strictly, it's very easy to distinguish the precedent, right? Because rarely do two cases have the same facts. Okay. In his joke formulation, it was, the rule of this case applies only to pale-headed Walpoles in red magenta Buicks, I think it was, right? Now, Llewellyn was a very good lawyer, so he understood that was a kind of facetious and extreme example. But certainly, you can find lots of cases where an unwelcome precedent, as Llewellyn would put it, is distinguished on the grounds of a factual difference that you might say, well, is that really a relevant factual difference? By contrast, you could read a precedent very loosely. That is, you could treat the precedent standing for an abstract proposition stripped away from the particular facts of the case, and then treat that particular precedent as authoritative. So too, the American realists thought in the case of statutory interpretation. Well, if that were true, that is, if legal reasoning were indeterminate in some of these cases, then the question arises, what is the court actually doing? Why are they deciding as they are? And the general American realist theory was that courts are indeed sensitive to the underlying facts of a case. And by the underlying facts, I don't mean the facts that the rules or doctrines they invoke would make relevant to the decision. Obviously, that's not surprising. It was rather that they thought judges were sensitive to what they called situation types, factual patterns that recur, but that you wouldn't recognize from the doctrine they invoke as being relevant to the case. I give you just one example, which I mentioned in the paper. There's a couple of other examples in the footnotes. So an American realist guy named Herman Oliphant said, here's 2 lines of cases, promise not to compete cases. These are all cases where someone has made a contractual promise not to compete with someone else. And Oliphant says, you look at these cases and sometimes the courts enforce the promise and sometimes they say, no, the promise isn't valid and they don't enforce it. And Oliphant's claim is contract doctrine makes no sense of it, right? You can't, as it were, divide these lines of cases up sensibly in terms of, well, there's failure of the meeting of minds or, mistake of a significant fact or whatever doctrine you want, it doesn't seem to fit what's actually going on. What's actually going on, Oliphant says, is that in the line of cases where the courts enforce the promise not to compete, those are all cases involving the following situation type, namely, sellers of businesses promising not to compete with the purchasers. Okay? And in those cases, the courts find a way to enforce the promise. Why, according to Oliphant? Well, his answer is put a bit elliptically, but I think what it boils down to is because it wouldn't make any economic sense to enter into those transactions unless those promises were enforced, right? If I sell you, my famous restaurant, Brian's Diner, right? And I sell it to James, and then I move across the street and open up Brian's Diner number 2, right? That defeats, right, the point of this transaction, right? The customers will just move across the street. Okay, so that was one line of cases. Now, what about the line of cases where the courts didn't enforce the promises? Oliphant says they all turn out to have something in common too. Namely, they are all promises by employees not to compete with their employers after leaving the employment relation, right? And why did the courts invalidate those? Well, according to Oliphant, because the trade guilds at the time, sort of proto-labor union organizations, strongly disfavored these kinds of contractual arrangements because they thought the bargaining power was very unequal between employee and employer. And you might also argue it really wasn't economically productive to forever bind the baker's apprentice to the baker and not let that person go out and do their work elsewhere. So notice the structure of the explanation for these decisions, and this is true across the board on every topic the American realists wrote about, is they would say the courts are busy reciting certain very general doctrines that don't actually illuminate the non-legal considerations like economic efficiency or, what would be fair, right, that are actually important to the decisions, right, and that track the underlying situation types of the cases. Let me emphasize in this regard that this aspect of legal realism was connected to their interest in law reform, because what people like Oliphant thought and what Llewellyn thought, Llewellyn was the author of the Uniform Commercial Code, which was very important in American commercial law in the 20th century. What they thought was that you could make the legal doctrine, right, more helpful for figuring out what the courts would do if you restated it at a level of factual specificity that picked out the normative considerations and the situation types that the courts actually cared about. And the restatement second of contracts in the United States actually adopted something like Oliphant's distinction between different kinds of promise not to compete cases. Now, why do I say that the realists were tacit legal positivists? Well, notice that the argument for the American realist position starts with a claim about the indeterminacy of legal reasoning. But you can't formulate any argument about the indeterminacy of legal reasoning without having some view about what the boundaries of law are, right? And when you look at the realists, when they make these indeterminacy arguments, they basically treat certain kinds of authoritative sources, right? Statutes, precedents, the kinds of things the American rule of recognition would pick out, right, as sources of law. They treat that stuff as the law, and they treat any of the stuff that lacks that kind of pedigree, right, as extra legal consideration. And that's why I think it's crucial that for their arguments to make any sense, they have to, in effect, be tacit legal positives, right? Because otherwise someone could come back to Oliphant and say, oh yes, courts are moved by considerations of economic efficiency when the maker of the promise is a seller of a business, right? But that's just because economic efficiency is a legally binding norm on the judge, right? And Oliphant clearly doesn't believe that. By the way, even my Chicago law and economic colleagues don't believe that. They're all legal realists. They think economic efficiency ought to be relevant to the decision, but they don't actually think that it is necessarily a legally binding norm. Okay, so that's the American realist. Now, H.L.A. Hart famously criticized legal realism in Chapter 7 of The Concept of Law. And here I'm just going to recap some arguments I have made previously, though with a slightly different conclusion than previously. So Hart distinguishes two kinds of rule skepticism. By rule skepticism, he means the view that the law is sometimes indeterminate. Right? I call one of them conceptual rule skepticism, the other empirical rule skepticism. The conceptual rule skeptic says there's nothing more to law than whatever the court decides or a prediction of what the court will decide. Okay? That's all law is. And Hart argues, I think, completely convincingly against that as an adequate account of the ordinary concept of law, right? So famously, the predictive theory of law that he's attacking, right, means that a judge asking herself, what's the law governing this dispute, is really asking herself, what do I predict I'm going to do? But that's nonsense, right? The law is asking what standard might be relevant to regulating the decision about what I ought to do in such a case. So yes, Hart is right, conceptual rule skepticism is false, but then the crucial question is, who's actually a conceptual rule skeptic? Okay? Now, the American realists do sometimes say things that sound like conceptual rule skepticism, right? And this is what Hart was picking up on. But it's very clear, I think, in context that they are not offering this as an account of the concept of law. Right? Indeed, if you said to any of these rather practical and mundane lawyers and judges who were American legal realists, what's your account of the concept of law, they wouldn't have known quite what you were asking them, right? They weren't ordinary language philosophers, right? They weren't thinking of that as their problem. And in context, when the American realists say things like law is a prediction of what the court will do, it's always in the context of a kind of practical heuristic for the lawyer. That is, if your client comes to you and says, here's what Jones did to me, right? You think it's worth suing them, right? What your client wants to know is, well, what's going to really happen if you sue him, right? They don't need you to recite some proposition from a treatise to them. They want to know what's actually going to happen, right? Am I going to recover? Is it worth the time? And so on. And in context, that is always the context in which the American realists say this. The complication here is, well, on the American side, Felix Cohen, the guy with a PhD in philosophy. And this may not be fair to Felix Cohen, but I haven't been convinced otherwise. I don't think his PhD in philosophy served him well. That is, he does actually seem to argue that it is philosophically fruitful to think of law as a prediction. The interesting thing is H.L.A. Hart nowhere refers to Felix Cohen, right? The realists he refers to are Holmes and Llewellyn on the American side. And in the case of those two, it's very clear it falls into the practical heuristic camp. On the Scandinavian side, because the other realist that Hart refers to in the notes at the end of the book is Alf Ross. Now, Alf Ross did actually propose that we should think of legal obligations, for example, as predictions of what courts will do. So to say that I have an obligation to pay you $500 for the widgets is just a prediction that if I don't pay you, right, you can go to court and the court will make me pay you something, right? Ross does say things like this. And there's actually a new translation of Ross of Law and Justice that's going to be out fairly soon from Oxford that I think will make clearer than the original translation. Ross himself had some role in the original translation. Problem is his English wasn't very good. And so he missed certain distinctions that were clear in the Danish. I've had this explained to me by Danish speakers. I don't read any Danish. And the new translation will make this clear. Ross is actually very clear that when he says we should think of obligations as predictions about what the courts will do, that doesn't do any justice to the ordinary concept of law. That's not what people mean when they talk about law. Right? So he's not doing ordinary language philosophy when he says something like that. And in fact, there are things in Ross that make it clear that he would agree with Hart's criticism of conceptual rule skepticism. So what was he doing? Okay. Well, this goes back to what were the Scandinavian realists really interested in? The location problem. He wanted to know, how can we make sense of talk about obligations and duties, right? When, of course, in a world naturalistically conceived, there are no such things. Okay? And Ross taught on a law faculty, so it probably would have been bad to go to the dean and say, listen, you've got me teaching contracts, okay? But actually, there's nothing there. Right? There are no obligations. This was his attempt to solve the location problem by showing how we could think of this language, we could translate it, we could treat it as shorthand for empirical descriptive claims about behavior. So it was very clearly in Ross offered as a revisionary, right? Not the ordinary sense of law, but a way of thinking about crucial concepts in law that would make them metaphysically respectable from a naturalistic point of view. Now, the more interesting debate between Hart and the American realists pertains to empirical rule skepticism. This is E on the bottom of page 2. Remember, Hart himself is an empirical rule skeptic, right? At least at the margin of rules, as he says. Right? That is, the empirical rule skeptic says there are some cases where law does not explain the decision. Right? The law is indeterminate, and therefore the law does not require an official to decide one way rather than another. Note that Hart's argument for this kind of rule skepticism is different than the argument of the American legal realists. Okay? Hart's argument famously appeals to the nature of language itself. Right? He says, language is in its nature open texture. General terms, right, have core meanings, which you can think of as competent speakers of the language will all agree that the term applies here and doesn't apply there, right? That, competent speakers of English know this is a bottle, right? And this is not a bottle, okay? And someone who wants to have a quarrel with me about whether this is a bottle is just not a competent speaker of English, so we should all go home. It's not worth fighting with that. At the same time, general terms have penumbral instances, that is, where competent speakers of the language will be uncertain or disagree about whether the term applies. Hart's famous example was vehicle. These days I always, I poll my students about segways. Do you have segways here? You know, segways are those things, right? I always mystified why people don't fall over. Where it's a base with two wheels and the whole, are those vehicles? And it turns out competent speakers of English, some think they're vehicles, some say, well, they're a little bit like vehicles, but they're not quite, and so on. All right. And Hart thinks that is the key source of indeterminacy in law, is that language just has this feature built into it, that there are penumbral cases, and when the central facts of the case fall within the penumbra of the words in the applicable legal rule, then it will be, the judge will have discretion to decide how the case is supposed to come out. But as I mentioned already, the American realists made almost nothing of the potential ambiguities of language itself. Their arguments were specific to what they took to be legitimate canons of interpretation that were available to judges, but that would produce conflicting readings of the rule of a case or the rule that a statute stands for. And I want to emphasize that the bit about legitimate but conflicting canons of interpretation. I take it what the American realists always mean by legitimate here, right, is legitimacy in the sociological sense of members of the legal profession would recognize those as available argumentative moves, right? That both these readings are possible readings. Not every reading is going to be legitimate in that sense, right? I think that's certainly true about the red-headed Walpoles and pale magenta Buicks example that Llewellyn himself gives. He had to know that that's almost always going to be a non-starter. All right, so they had very different arguments for indeterminacy. And then, as I say, this is F on page 3. Hart's real response to the realists on empirical rule skepticism is basically non-responsive. He says, it is surely evident that for the most part decisions are reached either by genuine effort to conform to rules consciously taken as guiding standards of decision, or if intuitively reached, are justified by rules which the judge was antecedently disposed to observe and whose relevance to the case in hand would generally be acknowledged, right? And the problem is the argument is it is surely evident. And that's just to say it is surely evident what the realists are denying is in fact the case. However, there's a real ambiguity here, right? Because Hart himself says law is indeterminate at the margins of rules. The American realists, at least when they're being sober about this, they're not always sober, they're not philosophers, they are, as I say, they're rhetorically exuberant at times, right? But when they're being sober about it, they're pretty clear that the indeterminacy they're concerned with is most evident at the level of appellate review. Right? So you might think that's already getting to the margin of rules. And it might be at the end of the day that they really aren't disagreeing about this. Right? That maybe part of what's really going on here is just some unclarity about the scope of the claim about indeterminacy, and it's compounded perhaps by the American realists because they're so court-focused, they don't, as it were, start with, though as far as I can see, they have no reason to deny H.L.A. Hart's fundamental point that law operates primarily outside of the courts. And then when you get within the courts, you get some indeterminacy, and Hart could perhaps agree you get more of that as you go up to the stages of appellate review. Maybe we can talk in Q&A about why American-style realism never got any traction in the UK. I suspect something is probably true here as well in Singapore, given that it's also a common law system reflecting a lot of the English influence. But I'd be glad to be corrected on that. All right, I'm just going to talk about one more thing since there are a number of students of Raz in the room, so maybe they will come to the man's defense. I actually think that, and the more I think about Raz's view, the more I think he really departs quite a bit from what I was characterizing as the realism of Hart's own legal philosophy. And I think this is clearest in Raz's famous authority argument for hard or exclusive legal positivism, right? And this argument starts from the observation that all law claims authority. That is, all law claims, right, at least with respect to the matters that it addresses, the right to tell its subjects what it is they must do, to exclude, right, from consideration, right, any of the dependent reasons, as Raz would say, on the basis of which the directive was formulated. Okay? Now, I want to agree with Raz partly about this. I think he's right that all law does claim this kind of authority, right? It says the law has spoken, right? I mean, you see this in the common trope in American TV, right, where the guy gets pulled over for speeding, right, and he starts explaining to the cop all the reasons why he had to be speeding. And the police officer says, tell it to the judge, right? And then when the person tries to tell it to the judge says, I'm not interested, right? Unless it's a necessity defense. But that's because the law recognizes a necessity defense for violating the law, right? So the law just says preempts, right? We're not interested, this is what you have to do. Now, what Raz adds to that, I think, is something very unusual, which is that Raz adds the thought that the kind of authority law is claiming is what he calls the service conception of authority, right? And the service conception of authority, as many of you will know, is the idea that when the law says this is what you must do, right? If that claim to authority is legitimate or justified, it's because you are more likely to do what you really ought to do by following the law's directives than you would if you tried to decide on your own what ought to be done, right? That is the service an authority performs for you. It performs the service of bringing you closer to what Raz calls right reason being what you really ought to do, given the balance of reasons applicable to the matter, right? And law is claiming that kind of authority. Now, there's one kind of worry about this whole picture from a naturalistic point of view, which is how to make sense of this talk about right reason, right? Raz, who sort of, internalized these sort of unargued for, as far as I can tell, anti-naturalism of Oxford philosophy since probably the 1970s onward, he doesn't share this particular worry, right? My worry is he's talking about a lot of entities, reasons that may not exist in the way he thinks that they exist. But I'm going to put that very skeptical and radical doubt to one side. My real worry here is that I don't see why we should think that the kind of authority law claims is the service conception, right? And I actually don't see any evidence for thinking that's the kind of authority that law is claiming, right? I can agree that law claims to be giving exclusionary reasons for acting, to use the Razian language, okay? But I don't see that they're claiming that in so doing they're performing a service for their subjects. Okay? Now, Raz, of course, I think went to this, and I think is a matter of the sort of the genealogy of his own thinking. This is the explanation. He invoked the service conception of authority in an attempt to respond to a worry posed famously by Robert Paul Wolff in Defense of Anarchism in 1970, which presupposed certain Kantian views about what it was to be a rational agent. And the thought was a genuinely rational agent, right, couldn't possibly defer to the will of another consistent with their rational autonomy. Yeah? And I think Raz's service conception responds to that problem. It shows you can be a rational agent and have a good rational reason to defer to an authority insofar as the authority helps bring you closer to right reason than you would on your own. Okay? But the problem here is that that particular problem, right, that Raz was trying to respond to depends on the Kantian notion of what's involved in rationality. And as I say, rather snidely, it presupposes a view of rationality no one rationally need accept. So I don't think that's a good enough reason for reading into law's claim to authority, right? The thought that it is a claim to the service conception of authority. All right, now I've gone on for about 45 or 50 minutes. I think I'll stop there, though if people want to talk about what this means for the exclusive, inclusive legal positivism debate and so on, which I address in the paper, I'm happy to talk about that, as well as anything else in the paper that I didn't touch on. Okay, thank you.